I'm Ken Carlson. I've been an attorney helping tenants since 1980. I'm a graduate of UC Berkeley and Loyola Law School. I've operated the caltenantlaw.com website for over 25 years. There you will find more videos, helpful materials, and lawyers to help you. I want to empower you. This video is about residential security deposits, not for business rentals. The handling of your security deposit is not casual, but is heavily regulated by Civil Code 1950.5. That law has continued to grow because of all the ways that landlords have tried to steal it from their tenants. The security deposit is your money. Its purpose is to protect the landlord in case you fail to pay rent, damage the place, leave it unclean, or take things from the unit. It includes all money paid up front beyond your first month's rent and a background check charge of up to $30 per person, except if you're paying at least 6 months' rent up front at once. The deposit includes pet deposits, cleaning fees, last month's rent, key and garage opener deposits, preparation charges, and any other names the landlord may try to use to collect more money from you, even if your lease dishonestly tells you otherwise. No part of it can be made non-refundable. The amount of the deposit that can be charged is a little more complicated. The new general rule is that the deposit can't be any more than 1 month's rent. It used to be 2 months and up to 3 months' rent for a fully furnished unit. If the rent is increased, so can the deposit. There are 2 exceptions to that rule. The first is for a deposit already collected before July 1, 2024, when the new law took effect. The second exception is intended to protect the small-time landlords. It allows 2 months' rent security instead of 1 month. To qualify, 2 things are required. First, the landlords must be people, which includes a family trust, or an LLC, which is a hybrid of a corporation or partnership, whose members are all people. The second qualification is that they own no more than 2 rental properties with a total of 4 rental units. If they have 5 units but live in one of them, they still qualify. Of course, the problem with this exception is that it can be difficult to find out those details on your own. Unless you're being evicted by a 3-day notice, the landlord is required to tell you in writing that you have the right to a preliminary inspection 2 weeks before you leave, and to be present for it. Always ask for that. The landlord must hand you a written list of proposed deductions for cleaning and repairs. You can agree on a date and time, but the landlord must give you 48 hours notice of his inspection. If the inspection is done too close to your last day for you to fix things, he violated that law. That list is important because he can't deduct for anything that is missing from the list unless it was hidden or occurred after that inspection. To deduct for damage, it has to be something that you caused and beyond normal wear and tear. If it happened without your abuse, like a faucet breaking from metal fatigue during normal use, you did not cause it. Scuff marks on the floor, screw and nail holes in the wall, and worn carpets are examples of wear and tear. Here's the test. Does the judge do it? Painting cost is not a valid deduction in most cases because it is not a repair and is always done to attract new tenants. If you caused it, fix it. If not, take pictures of it and make notes about why it wasn't your fault. In the future, you want to make it a habit to inspect the new place right away and photograph and identify every defect in writing to let the landlord know about it. That way, you avoid being blamed for something that pre-existed your tenancy. Your obligation to clean the premises is limited to its condition when you rented it. If there was dust, the carpets were stained, the oven wasn't cleaned, or the bathroom was not cleaned when you first moved in, you can legally leave it in that condition when you go. The landlord cannot require you to professionally clean the carpets or any parts of the unit. However, it's best to hire a maid service to clean after you've removed all of your furniture so that you have a receipt that says deep cleaning and pay a lot less than the landlord will charge. Before you leave, take pictures of how you left it. In each room, a picture from 2 opposing corners showing the ceiling and floor, as well as closer portions of the kitchen, bathroom, and other features, and close-ups of any defects. Remove any personal property, trash, garbage, or boxes. If you have a yard or garage, use the same approach. The landlord always claims that you trashed the place to steal your deposit, but you have these pictures to show the judge that he is a liar. Make sure they are good photos with enough light and clearly show what you are trying to capture. Video is not as good as still shots unless the action is important, like a leak through a ceiling or a noisy neighbor. After you leave, the landlord has to do a final inspection, and within 21 days of the day you left, refund your entire deposit minus any legal deductions. Make sure that he has your new address. The packet must be listed in writing, itemizing each deduction, and include all receipts detailing materials, time, and associated labor charges. The packet must include 3 sets of pictures. 1, before your tenancy began, starting July 2025. 2, immediately after you vacate, starting April of 2025. And 3, after the work or cleaning is done, to prove that each charged cleaning or repair was needed and done. If you don't get that, demand it in writing. All charges must be reasonable and exclude the total wear and tear depreciation. If you stained a 10-year life carpet after that 10 years, you damaged trash, not a valuable item. If you have to sue the landlord to collect your deposit, you can use small claims court for up to $12,500 in claims, or regular court for any more than that. The landlord has the burden of proof as to any deduction and the reasonableness of the amount, and whether it was needed. So, if it's your word against his, you win. If the landlord fails to refund or account for your deposit by mail or in person within 21 days after you left, meaning no longer sleeping there, he waives any deduction from your deposit, even legitimate ones. If he fails in bad faith to provide the documentation for the deductions, including the receipts and photos, he waives the right to deduct any item from your deposit, even unpaid rent. If he withholds any part of the deposit in bad faith, you are entitled to not just your withheld deposit, but up to double the amount of the total deposit as a bad faith penalty, as well as additional losses you incurred as a result of that failure. If you have to sue the landlord for your deposit, you might as well throw in other things to sue him for, like the uninhabitable conditions you endured from things he didn't fix, or his trespass and invasion of privacy, or his fraud in failing to tell you about the defects in your unit in order to trick you into renting it. Watch the Suing Your Landlord video on my website to give you more ideas about that. So, get out of victim mode. Take action. You just need to do the right thing and enjoy the benefits.